This meeting is being recorded.
Good morning, everyone. Thank you so much for taking time out of your week to join us for our Q3 seminar on leading workplace investigations. I have Mitch here, who I don't think many of you have had the opportunity to meet yet. He came on board with Ironwood about a month ago and has done many of these presentations on this subject in the past. So I'm thrilled to have him presenting with Kyle on this. And Kyle, of course, I know many of you are familiar with if you attend our Clear Up the Chaos, the second Tuesday of the month. If you haven't had an opportunity, if you would kindly mute your computer so we don't have any background noise and we can easily hear. I would like everyone to go to www.menti.com. You can see that there on the screen. We're going to be using the platform Mentimeter to help us through this presentation. It allows us to get information and see how you within your organization do things, some of your struggles that you might have, and this will help both Kyle and Mitch as they're presenting to see kind of our answers. So please, if you haven't already, go to that link, and then you're going to be asked to enter a code, and our code you'll see on the screen is 585072223. So 585072223. And I am going to hand things off to Mitch and Kyle for them to go ahead and begin. I know we have lots to cover, so we're looking forward to hearing all that y'all have to share with us.
Thank you, Elizabeth. So we do have an icebreaker Mentimeter question to help make sure that it's working, so it can go smoothly during the presentation. So we'll give you, a little bit to answer this first question, but if you wouldn't mind using your Mentimeter code, and perfect, results are coming in. So if you guys wouldn't mind doing that, we'll give it a minute, just making sure it works.
And if you are just joining us, you can see at the top of the screen, we are using the Mentimeter platform to help us through with this, and our code is at the very top. So if you're just joining, there is our code.
Yeah, and while we go through the presentation, if you're staying on Mentimeter, you can follow along the slides with us. So it has a couple dual purposes, but it's really fun to use. So thank you for taking part in it with us. We appreciate it. I'll give it 20 more seconds just to make sure everyone gets their vote in. I'm sure it's a tough one. We can keep going. Thank you guys. We appreciate you participating in that. So today we are going to talk about leading workplace investigations. My name is Kyle. I am the marketing and HR coordinator at Ironwood. I've been on a few of the Clear Up the Chaos sessions throughout the last few months, but I'd also like to introduce you to Mitch as well. And thank you, Elizabeth, for doing that introduction too. But Mitch is the newest HR team member for Ironwood. He is one of our HR coordinators, and he has he has a couple hundred investigations. He has done a couple hundred investigations at his previous role. So we're really lucky to have him, and great timing for this presentation, absolutely. So just a basic overview of what we're going to be covering today. So an overview of workplace investigations, some of the benefits for leading and effective investigations, the kind of a step-by-step plan on what would be considered a successful investigation, the do's and do nots, some conflict resolution tactics during the investigation, but also hopefully helping to avoid investigations and get the problem solved before it reaches that level, and just some common themes and examples that we have seen in our experience. So just the best definition of kind of what an investigation is supposed to accomplish. So it is conducted when there's a credible information that there may have been significant wrongdoing, misconduct, or ethical lapses. A workplace investigation may also be appropriate, even if there have not been specific allegations against an employee or department, but there have been allegations against others, and the investigation is intended to exclude the possibility that wrongdoing occurred within the company. So to kind of summarize that, good faith investigation leading to a reasonable conclusion with appropriate corrective action if necessary. So how are managers and HR professionals kind of informed that there might be an investigation that needs to take place? So the first is just that formal complaint. An employee begins the official grievance process. It could be brought to your attention anonymously. So some organizations have an anonymous hotline that employees can call in if they are experiencing any issues. It could be through a supervisor. So a supervisor witnesses behavior and they report it to upper management or HR. It could be indirect. So if you are just listening in on a conversation or just having a casual conversation and an employee says something that makes you think to yourself, well, that might need a closer look. Maybe we should investigate what they are telling me, even though they might have not made a direct complaint, they still made you aware of it. It could be from an ex-employee. So let's say it's an employee's last day and maybe you're doing that exit interview and they say, well, yeah, one of the reasons I'm quitting is because I, felt that I was not promoted and it was unfair. And then someone of a different gender was promoted to me, but we do the same work quality. We have the same amount of experience. So that is another way that employers can sometimes learn when an investigation needs to take place. It could also be from a third party. So maybe a witness even. I've had an experience in the past where one of my employees was talking to another employee and said they were struggling with a coworker who was making discriminatory remarks. They said, please don't say anything. I don't want to make a big deal about it. And then the coworker that they told came to me and again was like, you can't say anything. This is what they told me. Isn't that terrible? And I was like, it is terrible. And I apologize. I have to investigate it and, start that formal process because what we are hearing is not really acceptable. So we had to investigate it. So it could be from a third party as well. So what triggers an investigation? What are some things that you can, if you hear it, maybe they will alert you that maybe an investigation needs to take place. So phrases like, I did not get a raise because of my gender. Violence of any kind should warrant an investigation. Look for those buzzwords like bullying, unfair, bias, especially harassment, discrimination, racism, any mention of retaliation, unfair treatment based on protected classes. If you hear someone say, my supervisor's not fair, definitely any health and safety concerns. So not all complaints are equally serious. So how do you really tell the difference? Again, I would go back to especially those buzzwords. So like retaliation, harassment, discrimination, and even just listening for some of those unspoken issues, but just concerns that you might be aware of. So some common complaint areas. Discrimination, so anything based on age, gender, color, sexual orientation, nationality, disability, religion, personal beliefs. Harassment, so name calling, bullying, physical assault, intimidation, threats of violence. It could be sexual in nature. Health and safety concerns, so any workplace injuries or fatalities, absolutely an investigation. Violation of just employer rules. So that could be, repeated or serious offenses, but it doesn't necessarily have to reach that level. Anything dealing with theft, fraud, or criminal activity. So theft, misappropriation of funds, money laundering, extortion, fraudulent practices, any of those areas that are cause of concern should consider an investigation taking place. So some of the pros of having an effective investigation. So it reduces the risk of government intervention. It mitigates litigation or could perhaps limit the damages if a claim is brought against your company. A more engaged workforce. and increased management effectiveness. So if you think about it, a complaint can be considered an opportunity to solve a problem. So it also shows a commitment to policies, and it helps your employees know that if they make a complaint, that they will be heard and it will be investigated, and helps build that trust between an employee and their company. So some of the cons to having internal investigations are they are very time consuming and they can be costly. It takes a long time to go through this process. Sometimes, even if you are, trying to be as prompt as possible, it can still be time consuming. Information can be subpoenaed. So if there is a lawsuit pending, that the information gained from this investigation can be used. It may prompt an audit by a regulatory agency. There can be issues with external investigators and confidentiality. And possibly one of the biggest things is that it may affect the internal relationships in the culture. So even if you come to an agreement, just the lasting effect of investigations can have a great effect on just employee engagement, employee enrichment, and team building. So the role of an investigator. So first and foremost, you should act as a fact finder if you are leading the investigation. So you should think more of being a journalist rather than a prosecuting attorney, I guess I would say. So your goal is to find out whether allegations of misconduct have merit, who was involved, if there are disciplinary actions that need to be taken, and making sure that you prevent reoccurrence and also prevent future employer liability and any preventative steps to avoid future incidents. So that is the main goal. One common confusion, I think, when in terms of investigations, is you're not trying to decide if unlawful conduct has occurred. Internal investigations focus on facts and conduct, not legality. You want to know if there are policy violations occurred, but not necessarily if it rose to the level of illegal conduct.
So there are probably 8 steps of any investigation, but ultimately it's first step determining whether an investigation is required. With that in mind, you can then start to define your objective, create your plan, conduct your interviews, analyze the data. With that information, you can then develop your recommendation, determine your corrective action, and apply your findings and mitigate future risk. And we'll be going through each of these steps individually. So step 1, determining if an investigation is required. You're going to want to look at kind of how it came in. Was it a formal complaint or grievance? And the nature of it. So was a company policy violated? Has the company or an employee suffered a loss that resulted that stemmed from that misconduct? And has there been demonstrable misconduct? If it's things like harassment or bullying, it's probably going to warrant an investigation. Whereas if it's somebody made a face at you when they said good morning this morning, that may not be as applicable. So one key thing to keep in mind is protecting the complainant. One of the first things that I would always do when conducting an investigation is triage. So based on the nature of the complaint and the circumstances, you want the complainant to feel safe throughout it. You may need to place one or both of the complainant and the accuser on leave or look at adjusting schedules. Typically, it's more applicable in things like harassment, discrimination, so that you can put them in a position where they'll be protected through the duration of the investigation. So a couple of key things to keep in mind when having correspondence with the complainant. Don't promise outcomes. You can absolutely promise that you'll look into it, but don't start promising, oh yeah, we're going to get rid of this employee. We're going to terminate them, discipline them, things like that. Because when you're early in the investigation, you don't know which way this is going to go. The other big thing is you can't promise complete confidentiality. At the end of the day, you do need to still look into it. Complete confidentiality would mean you get the complaint, throw it in your shredder, file it away, don't talk to anybody about it. Let them know that you'll do your best to maintain that confidentiality, but complete confidentiality just doesn't exist. The other kind of big one that you want to keep in mind is don't discipline the complainant for reporting the complaint. Throughout the investigation, you may uncover that the complainant has actually violated policies and engaged in misconduct as well. You can treat that separately from coming forward with the complaint, but don't discipline somebody solely for reporting something in good faith. So step 2, you're going to want to define your objective because that'll help you control the scope of the investigation. A common mistake that I always saw, and one that I'm guilty of from time to time, was scope bloat. So when you're conducting your investigation, other allegations may come in. And if you just start expanding, it's pretty easy to overwhelm yourself. So it's a good idea to have a clear objective, whether that's to uncover stop employee misconduct, determine weaknesses in employer policies and procedures, limit liability for the organization, and to ensure employees are provided a safe and enjoyable work environment. So having that clear objective helps you narrow that focus and maintain that scope. So from there, you're going to want to start planning. So consider your timeline. So first step, consider your order of actions. Determine what triage is necessary, whether that's changing schedules, who you need to notify. It's always a good idea to make sure management's aware of what's going on. The last thing you want to do is place somebody out on leave and not notify management. Suddenly there's a gap in the schedule, creates a business impact. Consider your order of interviews. So first step, you always want to interview the complainant first, figure out the full context of what they're coming forward about. And then you'll want to interview the accused, figure out their side of it. From there, you can start discussing or having conversations with witnesses, gathering additional documentation, things like that, and try to determine the parameters of your confidentiality. Another big one that you'll want to consider is who will conduct the investigation, and we'll cover that a little bit more on the next slide. So supervisors and managers can step in and handle investigations for day-to-day infractions, your attendance issues, things like that. Where you want to start getting HR involved are things like EEO investigations, situations where there could be perceived bias from the manager. If this employee's been written up by their supervisor 4 or 5 times, having that manager handle their written final may not be advisable, just because the employee's probably going to have a perception of, hey, this manager's targeting me. So by having HR step in those situations, you can eliminate that bias and hopefully ensure a fair process for them. Terminations are also another big one, just because it does potentially open the company to some additional risk for a wrongful termination. So having HR involved in terminations is always good advice. General counsel, whether that's internal or external, typically they'll get involved in things involving high-level officials or extremely serious situations, such as potential criminal allegations or situations where litigation could be anticipated. So some pros and cons of each. HR, typically they'll have specialized job training or prior experience in conducting those workplace investigations. They'll have more familiarity with the business itself, and they'll have knowledge of business and employment laws. However, having your internal HR do it, the common perception, of course, is HR is there for the employer, not the employee. So they may perceive that as some bias, or if HR has a close personal relationship with somebody involved in the investigation. Both of those can contribute to a lack of trustworthiness in the HR staff. So if you bring in somebody from the outside, such as Ironwood, to conduct an external investigation, they're more likely to be perceived as objective as opposed to somebody internal. However, they may not have that intimate knowledge of the business itself, the history, the employee's history, things like that. And then if you bring in legal counsel, they can absolutely be objective. In-house will typically have more knowledge about the company culture than an external legal counsel. However, when the lawyers come in, it's definitely a lot more intimidating, so that may hinder the involved parties' ability to be open and provide information. So we could spend an hour covering all the great qualities of an investigator, but one of the biggest ones is their ability to be unbiased. At the end of the day, they're there to look into the situation and determine the facts, not necessarily take sides. Having familiarity with investigations is always a plus. The ability to maintain confidentiality is another key one. and ultimately somebody who can step in there, figure out what's going on and help make an informed decision based on the findings.
So that's going to bring us to our first Mentimeter question. So again, if you go to menti.com, if you aren't already there, and use code 58507223, I'm going to say the question and then you'll be able to add your answer after on the next slide. So the question is, Jane Smith emailed her manager stating that her supervisor, John Allen, has been making unwanted sexual advances towards her. In her email, she stated that John has been inviting her back to his office and texting her inappropriate pictures. Who do you think should conduct the interview? A, ignore the complaint to keep the information confidential. B, have the manager run the investigation. It is his team. Have HR conduct the investigation, given the sensitive nature of the allegations. Or D, fire them both for engaging in inappropriate relationships at work. So I'll give you guys, a minute or so to answer that question. And again, we think, wow, okay, I like this fancy, fast answers. Thank you for participating. We really appreciate it. I'll give just a few more seconds. Okay, and the correct answer is B, have HR conduct the investigation given the sensitive nature of the allegation.
Having the manager run the harassment investigation, in some circumstances you could, but given the sensitive nature of it, it's always a good idea to have HR involved in things involving harassment, discrimination, workplace violence, the very serious allegations. So step 4, conducting your interviews. Of course, you're going to want to determine who should be interviewed. That may change based on witness statements, things like that. You may find that there are additional witnesses you need to interview. A couple things you're going to want to cover first are discussing confidentiality. Again, let them know you're going to do your best to maintain that confidentiality, but complete confidentiality doesn't exist, unfortunately. Always stress that there's to be no retaliation. It's always a good idea to give them your point of contact, let them know, hey, if you experience anything you perceive as retaliatory, let you know so that you can address that quickly. Always stress the need for honesty. And then throughout your interviews, you're going to want to try and narrow down details. What I would always do is kind of a funnel approach. So you start off with, hey, what's going on? Tell me your side of it. It's going to start broad. From there, you start narrowing down, focusing in on your details so that you can establish a timeline. So your dates, times, it'll help you get an idea of any potential supporting documents, any potential witnesses that you need to interview. You can also stress what to expect throughout the investigation as well as after. You can give them a point of contact for who to reach out to with any post-interview questions. Above all, you want to try to set those expectations early with everybody involved. Throughout that, you're also going to want to collect any documentation and evidence that could be used to help determine an outcome.
So active listening is extremely important during these interviews, especially, but even in terms of conflict resolution in general. So to practice active listening, it's about giving each speaker the floor and really trying to understand their message without interruption. So the first kind of tip that we have to make sure you are practicing active listening is just plan to listen. So it means giving your full attention to and focus on the speaker and comprehending the information the speaker is sharing. So choosing to actively plan to listen is really the first step. Kind of limit talking, I guess you could say. So just listen more than you speak. If you're preparing a response rather than actively listening, the customer or the client might not feel heard or valued, or the interviewee might not feel heard or valued. And you can also miss key points. So if you are planning your response, that means you're kind of on play, whereas you should be more on record mode. So you make sure that you get all of those important details and that you hear everything correctly and that you can remember it later. Another way to show active listening is to paraphrase. So let's say someone just has explained how they felt about something, or they were giving an account of something that happened, you can say, just to make sure I heard you right, and then repeat back what they've said with those key points. So that shows you understand, shows that you're listening, shows that you're engaged. Also, active listening is exploring more. So asking those follow-up questions. The best way to accomplish this is to ask open-ended questions that encourage parties to speak more so than the yes or no questions. And in conflict resolution, if the discussion becomes kind of heated, you can also always ask each party to clarify how these processes were impacted by the situation, or what they need to do their jobs correctly. Restate what you kind of heard in your own words as well, to show that you understand what they're trying to say. To show people that you are practicing active listening, you can use listening indicators. So that's, the triple nod kind of thing, so that you show that you're engaged, saying, yes, I see. Those would be considered listening indicators. Focus is, probably the most important. So making sure you're eliminating those distractions and not multitasking, not checking email, not checking phones. Focus is probably the most important. If you are conducting a investigation over the phone and one of the witnesses happens to be remote or something, one way that you might be able to practice active listening is to even close your eyes and just really hear what the person is saying, rather than looking around, or again getting distracted. And of course, just having genuine interest in what the person is saying. Looking in the eyes, having your body facing towards them, kind of almost mirroring them at times. So those are just a couple of ways to practice active listening, which is extraordinarily important. But this isn't a Mentimeter question, it's just an active listening game, I guess you could say, that I really like playing with employees, or if I'm doing a training like this. So it kind of starts like, so you're driving a bus and 20 people get on the bus, 3 people get off the bus, 5 people get on the bus, 1 person gets off the bus. Next stop, 7 people get on the bus, 10 people get off the bus. And final stop, 8 people get off the bus, 13 people get on the bus. So my question is, what color are the bus driver's eyes? If you are answering a number, you might be right. I just threw random numbers out there, so I don't know the actual total there. But if you're curious, what color are the bus driver's eyes? That would be whatever color your eyes are, because I started the activity by saying, so you're driving a bus. So every time I use that exercise, it gets people to really start focusing in, like, oh, I thought I was an active listener and maybe I could use a little work. I know I could. The first time I heard it, I was so bamboozled, but it shows that you need to focus on, everything that's being said, not necessarily things people might be trying to throw you off like I was. I didn't really care about the number. I was just trying to see if you were listening. So I really enjoyed playing that, and please feel free to use that. I think I saw it in a movie, but it worked. Also, another skill that might be really helpful when you are having these investigation interviews is just ways that you can detect deception. So the best way is kind of just to get people talking. Don't be afraid of silence. If they're nervous, they'll try to fill the void, the silence void that might be in the room. So use silence as a tool, and definitely don't be afraid of it. Focus on listening rather than looking. So, the tone of voice. You might not be able to tell just by looking at someone, maybe they don't make eye contact, or maybe they're looking up and to the left, but those aren't actual indicators of truth. That could just be nerves. It could be a variety of different things. But if you focus on listening, that might help you detect any deception, because the average person does better at spotting lies just by hearing a person talk. You can also consider the fact that liars tend to give the bare bones account of something that's happened. So if you ask these follow-up questions, to elaborate and clarify, they might really struggle with that. Their initial explanation of what happened for the incident might be, to the point, whereas someone who actively experienced it, who's telling the truth, can elaborate. They might even be able to draw it for you. They might be able to tell you it backwards, you know, doing the sequence of events backwards. And that was very hard for people who are not telling the truth. And also it could help to ask unexpected questions. So those are particularly important when there are people trying to corroborate, or you know, there are witnesses and you want to make sure they're telling the truth. So asking unexpected questions, that's not something they'd be able to plan for if you're just trying to get down to, you know, the truth. Saying things like, please give me everything you can and as many details as you can. You know, watching nonverbals. Use silence, the tone of voice, observe body language, and repeat questions. So, you know, you ask it in the beginning of the interview and at the end of the interview. If the answer changed, that could mean that there is some deception. But you know, we're not actual cop investigators like everyone you see on TV. But those are just some ways that you might be able to help detect any deception that might be happening during interviews.
So evidence can take a lot of different forms. It could be things in their personnel file. A big part of due process is making sure that the employee is aware of the policy that they're violating. So an acknowledgement stating that they've read the handbook, things like that. Could be time cards if you're looking into time theft, things of that nature. Manager statements, prior disciplinary is a big one. Social media can get a little bit tricky. In situations where it could potentially be about the company or an employee, but it's not clear, as opposed to them specifically naming, hey, XYZ person was engaging in this behavior. Things like internet searches. The other big one that I always like to touch on are email and text. So if it's on a company phone or company email, company computer, feel free to dig through it. You can require that they turn that information over. However, if it's on a personal device, like a personal cell phone, you can request it, but you can't require them to turn over that correspondence. Another big thing that I've seen happen from time to time is if you get screenshots of text messages, just read through them and double check to make sure nothing's been deleted. I had one that was pretty apparent that somebody deleted it since it was only one side of the conversation. The employee or the complainant that had brought it forward had actually gone through and deleted all of his messages in it. When I requested a copy from the accused, they provided the full context of it. And it was pretty clear that the complainant was actually engaging in misconduct. So it's just something to keep in mind.
And that brings us to the next Mentimeter question. Again, I'll read the question, and then once I go to the next slide, you'll be able to add your answers. So the question is, after speaking with Jane, she voluntarily provides screenshots of text messages supporting her allegations. Do we still need to even interview John? Option 1, yes, even though we have supporting documentation, he should still be interviewed. Or option 2, no, we have documentation, his side is completely irrelevant. So I'll give it a little bit of time and let those answers come in. And everyone was correct. Yeah. Even though we have supporting documentation, we should absolutely still be interviewed.
So when you're going through and analyzing and validating your data, a couple questions to keep in mind. Was there an actual policy violation that took place? From there, you can start looking into, was the employee aware of the policy? And then once you've nailed down those two, you can then start looking at, okay, is disciplinary appropriate? Are there any mitigating circumstances to keep in mind? When you're looking at your evidence, you want it to try to be beyond a reasonable doubt. I know that's not always possible, but you always want it to be clear and convincing, and ideally you want a preponderance of the evidence to support it. So if it's a situation where you have multiple witnesses, try to look for the similarities in each one, so that if you have one outlier, but you have 5 people saying that the incident occurred, more than likely that incident did occur. Always make sure that your investigations are done in good faith. And it's always a good idea to keep the just cause process in mind, which we'll cover a little more in depth on the next page. So if it goes through arbitration or litigation, there's a couple additional factors that they'll look at. There's actually 7 steps of just cause, but broadly it boils down to, was progressive discipline followed? So I mean, were they receive, or did they receive a verbal warning, written warning, and so on before the termination? The treatment of the grievant in disciplinary and otherwise. Whether any probable punishment was communicated. So did the employee, or was the employee aware that their behavior could result in disciplinary? The practice of disciplining employees for the same alleged misconduct. So if you're disciplining Jane for something and John does the same behavior and you don't treat him the same, you're going to have issues there. So make sure that it's consistent and that you're staying in line with precedents. And then it's always a good idea to keep in mind whether or not there are rules or statutes prohibiting the grievance conduct.
This brings us to our next question. So after conducting all the interviews, you have a statement from Jane that the incident occurred, as well as interview notes establishing the time frame. Jane has also provided screenshots showing John sending her inappropriate pictures. John denied the allegations and provided screenshots showing Jane reciprocating and sending pictures as well. Based on this, do you feel that the allegations of harassment are warranted? A, yes, based on the information, John was harassing Jane. B, while not harassment, John may have violated the workplace relationships policy by approaching a subordinate. C, we don't have enough information to substantiate any policy violations. Or D, both employees should be fired. Give it a little bit of time. Fantastic. Oh, and nailed it. While not harassment, John may have violated the workplace relationships policy by approaching a subordinate.
Yeah, and we deliberately, when we were crafting this, chose kind of a tricky situation. This was actually an investigation that I had handled at my previous company. The initial complaint was that it was harassment, seemed clear cut when we had the screenshots. But in digging into it, it was actually the complainant initiating most of the behavior, and the manager that was involved was more on the receiving end of the conduct, as opposed to the one initiating everything. So that's why it's always a good idea to look at the totality of the evidence, as opposed to just drawing an initial conclusion and sticking with it and trying to find a way to support it. The other piece that I want to touch on this is based on the information there. It could potentially still be harassment if John was abusing the power of his position to try and coerce Jane into that relationship. Based on the investigation that I had, that was not the case, but it is just something to keep in mind. So developing your recommendations. When you're coming up with your recommendation, try to keep in mind what you'll base your decision on, whether or not there's any data that was eliminated, or if there are any gaps that still need to be filled in. Do you feel like a burden of proof is met? Because at the end of the day, you may need to defend the decision and recommendations that you're making. So trying to make sure that you have enough evidence that you feel confident in the outcome is key. And then just cause, it's always something to keep in mind. Just make sure that you're satisfying that criteria. So when you're determining your corrective actions, it's a good idea to adhere to your policies and procedures as well as past precedents. So look at things like the severity of the misconduct. If somebody drank the last coffee in the break room and didn't refill the pot, that may not be something you want to term for on the first offense. Whereas something like harassment, workplace violence is something that you probably want to separate employment for, depending on the circumstances. Look at if there's any mitigating circumstances or prior disciplinary history. You'll also want to look at, like I mentioned, precedents for similarly situated persons in situations where you don't necessarily have a precedence. Offender's remorse can be a little bit tricky. When we were working on this, Kyle had an example where an employee had accidentally stolen some tips, and they were in the process of returning those tips when it was uncovered that they had actually taken it. From my end, it was a situation where an employee had stolen a phone, went ghost for 2 days, and didn't express any sort of remorse until the supervisor showed up at the employee's house to retrieve it. So I would look more so at their actions to show remorse as opposed to just their words of saying, I'm sorry.
And so our question is, what would your recommendation be? The policy states that inappropriate relationships warrant a warning prior to separation. This is John's first offense. So what would your recommendation be? A, fire him, definitely can't be trusted. B, documented write-up and retraining. C, a stern talking to, or D, no disciplinary. John is a great supervisor. Yep.
Everybody's nailing these questions.
I
It's
know,
kinda
maybe they didn't need this training after all.
awesome. So when you're using your outcome to find and take remedial actions, at the end of the day, you want to try and make sure that this specific circumstance isn't going to happen again, or ideally prevent it if possible. Depending on the outcomes, though, you may not substantiate that any wrongful conduct occurred. Situations like that, it may be worth just sending out a policy reminder. Same with gray outcomes or unsubstantiated, where it could have happened, it couldn't have. Still a good idea to get that policy out there to the team and just remind the individuals involved, hey, this is the expectation going forward.
Thank you for calling Big Tex, and this is Peggy. May I help you?
If you do find that wrongful conduct did occur, it's always a good idea to remedy the situation, whether that's issuing a warning, retraining, on up through discharge if it's something serious. The best way to prevent that employee from engaging in the behavior may be to remove them from the company entirely. So as far as mitigating future risk, with any investigation, you're going to want to hang on to everything you've collected. It's always a good idea to keep a copy of the policy, procedure, or rule that was violated. With policies, if it's something in your handbook, I would try to snag the exact revision that you were using at that time. If you've updated your handbook since then, it's always a good idea to have that old policy there. That way you can refer back to the one that was in place at the time that was used. Things like interview summaries, copies of documents that were used to make the decisions. It's always a good idea to have a summary of the investigation that you can refer back to that has everybody involved, who was interviewed, what evidence was collected, as well as what your findings were and how you supported those. Hang on to a copy of any disciplinary notices, responses, any key findings, policy conduct findings. Basically, everything pertaining to that investigation should be held onto in the event that it ever comes up later. So I'm not sure if anybody in here has any union employees, but there are some additional considerations to keep in mind. With a union environment, there's going to be a collective bargaining agreement in place. You're going to want to consult that in addition to your policies. My previous company, the CBA actually outlined our investigation window, where we had 10 days from the date that we were notified to complete that investigation and issue disciplinary. If we fell outside of that, unfortunately, we couldn't move forward with any disciplinary regardless of findings. Weingarten is another big thing to keep in mind. So under Weingarten, employees do have the right to have a union representative present during any investigatory meeting that could potentially result in disciplinary. You typically have two ways you can approach that once the employee has invoked their Weingarten rights. You can either continue the meeting, the employee has no obligation to answer any questions from that point on, or you can stop the meeting and resume once a union employee or union representative is present. I generally recommend waiting until the union's there, just so that A, you have an extra witness, and B, it helps mitigate any potential risk from continuing and inadvertently violating their Weingarten rights. That said, Weingarten does not arise in situations where there's no disciplinary or you're not conducting an investigation. So if it's a training situation or you've already determined the disciplinary outcome and you're just informing the employee of the outcome of the investigation, Weingarten wouldn't apply. And then the other big thing to keep in mind is just cause. back when I was working directly with the union, one of the big things that they would attack during the grievance process was just cause. So above all, you're just going to want to make sure that you've dotted your I's and crossed your T's with any sort of union investigation.
So workplace investigations are often essential for serious allegations of misconduct. But what about the cases that don't rise to the level of an investigation, or cases that you find no policy violation is found, or what happens after the investigation is over and the employees have to figure out how to work again or work together again? So there are some conflict resolution tactics that you can engage in to either prevent the the need for an investigation and the escalation, and that you can even use, during the actual interview process. So, the first is just communication. So clear and accurate communication is essential to making people feel heard. It helps ensure all parties know exactly what is expected going forward. And working on emotional intelligence, understanding your own feelings and the feelings of others is highly important to averting, minimizing, and resolving conflicts. Empathy in general is very important to conflict resolution. That is seeing another person's point of view. It can reduce resentment, stubbornness, and can increase innovation and learning. It can create, a team environment. And one thing I always like to mention about empathy is that it is far, far different than sympathy. Sympathy is, I feel bad that that's happening to you. Empathy is, I know I can feel what it's like to be in your shoes. And another thing I always like to mention about empathy is, if someone is coming to you, if they are expressing, frustration, they aren't necessarily looking for an answer. Sometimes they're just trying to vent. So really just letting them do that and not trying to provide, what happened to you and how you would have handled it. It's just saying, I know you're struggling. I might not be able to fix it, but I'm going to walk beside you while you go through it. Another empathy tactic that I think is super important is, not to silver line someone's problem. So if they come to you and say, oh my gosh, my daughter got kicked out of school. And if your response is something like, well, yeah, but at least your son is making straight A's. So that's a term called silver lining, finding that silver line cloud. And it makes people feel, like they are whining and that they shouldn't feel bad. You're like, I guess you're right. I should stop complaining. And that's not the goal of empathy. The goal of empathy is, to make people feel heard, understood, and it really helps communication and conflict resolution. And just problem solving. So good problem solvers listen and find solutions that help different parties, different people. You're going to get so many different situations, and you're not going to necessarily be able to use a one-size-fits-all solution. So you're going to have to adapt to the different situations that come up. So being a good problem solver is absolutely a great conflict resolution skill to have. Additionally, so ways to manage conflict is, first and foremost, good policies and procedures, having a good fair grievance policy. So you should have written policies and definitions pertaining to dispute mechanisms available in your organization. They should have clear guidance. They should absolutely give, the scope and limitations, spell out, what can happen, the consequences, implement a really good system that resolves conflict within the company, can create incentives for employees to fix the conflict within themselves as well. It also can help improve employee morale because they have options. It isn't necessarily an investigation. It could be different ways of solving these problems. And a very helpful thing to have in mind is an open door policy. So it encourages employees to meet with their immediate supervisor to discuss and resolve work-related issues. And they should also, then they can also be aware that there will be no negative repercussions for voicing a complaint. Training, constant training, additional training, retraining. It is essential for creating, a solid conflict resolution culture and skills within your organization. effective communication and conflict resolution can absolutely be learned and developed with the proper tools and the proper training. It also helps improve communication skills. And it's very important when it comes to training your managers to make sure they're up to date on all of the regulatory changes and legal requirements necessary. You can also use a more mediation form of conflict resolution rather than a full-blown investigation. So mediation kind of creates that safe place for people to delve into those deeper issues. And an experienced mediator is able to identify where relationships might be struggling or when particular situations might need to be discussed. It's a neutral third party, and it can be someone in your organization already trained. A manager might be trained on these different conflict management and resolution skills, or it can be a third party, or it can be Ironwood. There's also group facilitation, and which is particularly useful if there are just underlying issues within a team. It encourages parties to avoid, personal attacks and focus on actual problem solving, using those I feel phrases rather than you made me angry. Helps people work towards an outcome, and it helps people or helps employees have that established and agreed upon plan that might help going forward. And it keeps the discussion towards achieving your goals. If you have these mechanisms in place to resolve conflict at the early stages, then employees will generally see your employer as being fair and your dealings with them, and likely more satisfied with their jobs. Whereas if you do not act, conflicts might escalate into larger problems. Discrimination and harassment complaints may increase, and it could hurt reputation overall. So the best conflict resolution is to try and catch it early on, rather than letting it escalate into those investigations. Of course, sometimes it's not going to be in your control. So some common mistakes employers make during investigations. So that's an absolute, failure to investigate at all. You are, someone tells you about a problem and you don't act promptly, or you don't act at all. And then later there's, you find out there's a claim against the company for failure to investigate, initial discrimination or harassment. Keeping a dangerous employee. I absolutely have experienced this. I had an employee who pushed down another employee. My preference was to let this employee go. I did not see anything positive coming from this interaction going further, but higher ups decided, well, let's give him another chance. We don't think it's going to happen again. Well, it happened again, and it escalated, and it's a decision that I would not make again in their shoes. So keeping a dangerous employee can be a common mistake. Delay, so not beginning the investigation timely, or ignoring their concern, or not acting because an employee asked you not to. Inconsistent in your recommendations. So if you had something that happened with another employee that they were let go, and then you did not let the current employee go, even though they're very similar. So inconsistencies. Retaliation, absolutely. So that would be someone comes to you with an issue and then they're punished for it, or they're treated differently after it. Confidentiality and privacy can have some tricky issues with it. Not remaining impartial. So if if the investigator is biased or has a conflict of interest, or shows favoritism, then also lack of experience and trainings. So almost all laws regarding to workplace rights of employees, including retaliation, harassment, they all require employers to undertake investigations in order to meet their obligations under the law. So the general duty of any employer who either knows or should know about discrimination, harassment, threat, or safety problems faced by an employee is supposed to take prompt and effective remedial action to put an end to the problem. So just to list some of the important laws and legal situations, so job discrimination laws, Civil Rights Act, ADA, ADEA, and the state equivalents, health and safety laws, so OSHA, laws and preventing further problems of workplace violence and duties to investigate threats and prevent acts of violence in the workplace to any extent possible, and just overall safety. Drug-Free Workplace Act of 1988 and DOT drug testing regulations, and then background checks and credit checks. So in order to minimize liability for negligent hiring or negligent retention, employers must sometimes investigate employee backgrounds, like Fair Credit Reporting Act requirements apply. So a few other things that might come up are like not closing or closing the investigation and not following up on the corrective action. So issuing your recommendation and then not actually following through with the punishment, or not going back and checking to see if it was effective or if there's a reoccurrence. Failure to proper documentation. Those are just a couple of the things that are a couple easy mistakes to make during investigation. And one very important thing to consider before you're ever hopefully faced with an investigation is to really consider what your investigation policy, or if you don't have one, creating one, what it says, and the different things it lines out. So a poorly drafted policy or common mistake is only having one avenue to make a complaint. So if your policy states, if you're having an issue, please report it to HR. Well, what if it's the HR manager that is causing an employee an issue? So some businesses utilize anonymous helpline, anonymous tip line. Also having a policy that says guaranteed confidentiality. You cannot always make those guarantees. You can do your best. You can limit the amount of people who have access, but you shouldn't ever guarantee confidentiality. Failure to include a no retaliation clause, and letting people know that it's okay, and they should feel empowered, and you want them to come to you with any issues, and that we will not face any retaliation based on coming forward. And failure to state possible corrective actions if there is an investigation and they do find that there was misconduct. That being said, we don't necessarily suggest you limit yourself and say, this is what happens. If you do this, you're fired. Give yourself some, wiggle room. State the possible repercussions. So whether that's a verbal write-up, a written write-up, a discharge, or, a suspension. So list the possible repercussions. So just to kind of summarize what we've talked about today, we hope that after this, you kind of know what might trigger an internal investigation, how to kind of create your investigation plan, how to pick the right investigator for the whatever arises. Remember that the goal is to fact find above all else, not necessarily make immediate judgment or to be that prosecuting attorney. You're supposed to fact find. And to make sure that you follow through on any corrective action. We'd really like to thank you for your time today. Mitch and I really appreciate it. You are more than welcome. You might have time for a couple questions if there are some, but if you have any additional questions that we're not able to answer, you can email us, and it reaches our whole HR team at hr@ironwoodbc.com. We also are in charge of the unlimited phone support and email support phone number. I don't have it here, but I'm sure Elizabeth has it, and I know she's really great about giving that to you guys. But we'd really like to thank you today, and call us anytime if you need any advice at all. We're more than happy to help.
So we thank you so much, Mitch and Kyle. We did receive one question that I'm going to try to squeeze in since we have 2 minutes left. In regards to a personal phone for work, work-related information on the phone is owned by the company as for the Public Information Act. If this is the case, wouldn't it be subject to the employer demanding any information in regard to an investigation?
So it gets a little bit tricky in there. So if it's a personally owned phone and the company's paying for it, if I recall correctly, then you have more wiggle room on it. As well as if it's a work related or a work email account that's sending the correspondence, that would be acceptable, but just going through somebody's Facebook on a personal phone, typically not advisable.
Okay, I appreciate that. And just a reminder to everyone, like Kyle mentioned, as clients of NCW and Sanford and Tatum, you do have complimentary access to Ironwood and their team of HR professionals. So if you do have issues arise regarding investigation, or if something's brought to the table that you have questions on and are just wanting a second opinion, I do encourage you to reach out directly to myself and I can get you that agreement. I always recommend that the agreement be signed prior to an emergency or a situation arising. So if you haven't done that yet, when I send the follow-up email regarding this seminar, I will include the agreement in there and you can sign that and return it. And then, like I mentioned, I will be sending out the recording and the slides. So if anyone is within your organization was unable to attend today, they can view this at a later time. But I do appreciate your time and I hope you'll have a wonderful weekend. Thanks so much.
Thank you, everyone.
Bye.